Supreme Court of India Shoor Singh and another versus State of Uttarakhand decided on September 20, 2024 SCC Online SC 2595 Facts of the case. The deceased, Neelam, who was daughter of Shankar Singh, prosecution witness 1, and Sarojini Devi, prosecution witness 2, was married to appellant's son Jitendra Singh, co-accused, on March 1, 2006. On December 30, 2006, deceased gave birth to a male child. On January 17, 2007, deceased died at her matrimonial home due to extensive burn injuries. It was alleged that when prosecution witness 1 and prosecution witness 2 visited deceased's matrimonial home on January 11, 2007, the deceased inquired from prosecution witness 1 and prosecution witness 2 whether they had brought motorcycle and cash FIR, which was registered under sections 304B, 498A IPC in sections 3/4 Dowry Prohibition Act, 1961, against 3 accused. The trial court, the accused convicted for dowry death. High Court affirmed conviction of appellants under sections 304B and 498A IPC. Findings of the court: appellants are father-in-law and mother-in-law to constitute a dowry death, punishable under section 304B IPC. Following ingredients must be satisfied: death of a woman must have been caused by any burns or bodily injury, or it must have occurred otherwise than under normal circumstances. Such death must have occurred within 7 years of her marriage. Soon before such death, she must have been subjected to cruelty or harassment by her husband or any relative of her husband, and such cruelty or harassment must be in connection with any demand for dowry. The phrase "otherwise than under normal circumstances" is wide enough to encompass a suicidal death. When all the above ingredients of dowry death are proved, the presumption under section 113B of the Evidence Act is to be raised against the accused that he has committed the offense of dowry death. In the instant case, it is not in dispute that the deceased died otherwise than under normal circumstances within 7 years of her marriage. However, the issue between the parties is about her being subjected to cruelty or harassment by her husband or his relative soon before her death in connection with any demand for dowry. The testimonies of prosecution witness 1, prosecution witness 2 and prosecution witness 3 do not indicate that any demand for dowry was made by the accused appellants either before or at the time of marriage of the deceased with their son. Further, there is no evidence that the accused appellants directly demanded a motorcycle or cash from any of the above witnesses. In fact, evidence is to the effect that the deceased had informed prosecution witness 1 and prosecution witness 2 on January 4, 2007 and January 11, 2007 about the demand for a motorcycle and cash. Further, from the deposition of prosecution witness 1 and prosecution witness 2, it appears that the aforesaid demand was not in connection with marriage but as a mark of celebration on birth of a male child. In the instant case, the witnesses PW1 and PW2 were asked whether they took up the issue of motorcycle/cash demand with the accused. Their reply was that they did not because they took it as a joke. We fail to understand how parents could treat their daughter's multiple reporting of apprehension to her life on account of demand being not met as a joke. This creates a serious doubt about the truthfulness of the allegation, more so when there is no allegation that any such demand was ever raised either before or at the time of marriage. Moreover, the presence of the accused in the house at the time of occurrence is not proved. In such circumstances, the death was most probably suicidal, though this would not make a difference for commission of an offense punishable under section 304B IPC if all the other ingredients of dowry death stand proved. Once all the necessary ingredients of dowry death have not been proved beyond reasonable doubt, the presumption under section 113B of the Evidence Act would not be available to the prosecution. Hence, in our considered view, the appellants are entitled to be acquitted of the charge of offenses punishable under section 304B and 498A IPC. The appeal is accordingly allowed.